In November 2014, President Obama made important changes to the program called Provisional Waivers of Unlawful Presence. Attorney Scott McVarish is going to tell us more about those changes and what that means for you, the potential applicants.
Provisional waivers are pretty new to begin with. They've only been around for 2 years prior to President Obama's November 2014 amendments. Provisional waivers are a great thing for many of our clients who previously had U.S. citizen spouses or U.S. citizen sons or daughters 21 years or over. They would be able to get their green card even though they themselves were undocumented or perhaps had overstayed their visas. And instead of having to return to their home country to do the entire process, which took anywhere between 6 months and 10 years if the waiver was not approved, they were able to do it here in Los Angeles with our office. Or if they were somewhere else in the United States, they did it by phone with our office. That was great. What President Obama just did in November 2014 was expand that to encompass sons and daughters 21 and over and spouses of legal permanent residents. Okay. So if you're undocumented, but you have a spouse or son or daughter 21 or over who is a legal permanent resident or U.S. citizen, you now may be eligible to apply for unlawful waiver.
Okay, and what does one have to establish in order to be eligible for the waiver?
You have to be able to show that the person that you would be leaving behind if you left the country would suffer extreme hardship. And it's not just the type of hardship that you'll miss your spouse or your sons and daughters 21 and over would miss you if you were to leave. It has to be something more. It's a complicated type of case, but we've had tremendous success in our office with these cases. We'll go through your entire financial portfolio. We'll go through a psychological makeup with you if necessary. Perhaps there's health issues involved. We'll find something to create a compelling story because that's ultimately what it is. When we apply for the unlawful waiver, what we're doing is we're sending a package and a letter about you and your life to a USCIS officer. And we want to be able to move them. And we want to make them understand why it would be such a big deal to lose your spouse if your spouse was denied a green card in the United States, or to lose your parents if they were denied a green card in the United States. Or conversely, how if you had to go with your undocumented spouse or parent and move to another country, what type of hardship you would suffer by going to another country and leaving the United States. It's all about a story, and that's what we do in this office. We get to know you, we understand you. Oftentimes we learn more about you than even your spouse knew because we need to go back into that history. Everything is confidential with just your attorney and with a USCIS officer who is in another state, but it's important we get that level of detail so that we can tell that compelling story about your life to get you that green card and frankly to change your life once we do.
Absolutely. So the hardship means documents, not just a story that you would tell, but
That's
documents that you could present.
That's right. So we get the documents. Sometimes we'll even refer people to outside psychologists who will give us a 8, 9, 10, 11-page report about you and your life. Some people find it cathartic. Some people find it stressful. One way or the other, it's something we do send about half those clients to get in order to strengthen their application. But when we get those documents, we weave them together into that story of your life. And sometimes it's a beautiful story that we've told and that people have really come to cherish so that their family understands where they've come from and what they've gone through to get to this point. And it's an honor for us to be able to put that together for our clients.
It's wonderful. Thank you very much.
All right.